So I'm going to talk about what happens after school. Again, my name is Mark Topolewski. I was a graduate of Michigan State in 1993, economics major, and I went to law school at Vanderbilt, and I'm managing attorney Bellis Porter, which is an immigration law firm. We're based in Troy, Michigan. But we help people from all across the state and all across the United States. What we're going to talk about today is, again, what happens after graduation. And first, I like to just highlight the impact that you as PhDs you make on our economy. You're some of the best and brightest in the world, and I think it's fortunate if we can have you stay here in the United States and apply what you learned. And it's a proven fact that the knowledge that you bring and contribute to our country makes the economy better. We're also going to talk about how to transition from an F1 to an H1B, which is really the most common work visa category available. And we'll also talk about transitioning from J1 to H1B, because then we have a couple J1s. And then we'll talk about green card or permanent resident status options. And then also, you may have seen back in November, President Obama announced his executive action on immigration, which had a lot of proposals that had to do with illegal immigration, but it also had a lot of proposals that will help with employment-based immigration topics, and we'll talk about that as well. So one, I love sharing these stats because I think it just shows how impressive you all are and what you do when you leave Michigan State. But again, 50% of all PhDs in engineering and 45% of the PhDs in these other areas are awarded to foreign-born students. When you get out in the workforce in these very high-tech, knowledge-based fields, again, the PhDs are the people holding foreign-born PhDs are holding a very high percentage of these positions. Immigrants and PhD students are also very entrepreneurial. You get out into the economy and you don't just sit around, you guys do things. You start businesses, you start companies, and you create jobs for America. I think that's amazing. Michigan ranked 3rd in the nation as far as how many businesses were formed by foreign-born students. I think that's amazing. Also, almost a quarter of the patents in the United States are filed by immigrants, and in Michigan, over 35% of the patent applications are filed by immigrants. And immigrants are more than 6 times likely than a person born in the U.S. to do that. So that's very impressive as well. And again, very entrepreneurial and very likely to start a business. So for all those, what we're going to talk about is because sometimes it may seem, I think it's so great to have you here and to have you be able to stay and contribute to our nation and our economy. Sometimes it doesn't feel that way though when you're navigating the system. So we're going to talk about what the system is and how to get through it as best we can. So just a general background of the U.S. immigration system. People can really only be here in 4 different very broad statuses. You're either here in a temporary visa status, which is called non-immigrant status, or you're here as a permanent resident or a green card holder, and that's an immigrant visa. You can be here as an asylee or a refugee, so you're fleeing the country because of dangerous conditions there, or you're a U.S. citizen. A lot of people think green card and citizenship is the same thing, but it's different. You apply for citizenship after you've been a permanent resident for a certain period of time. It can be a maze getting through the immigration system because you have to deal with so many different rules and regulations and so many government agencies. You're dealing with not only the USCIS, but the Department of State, the Department of Labor, and they're not always the easiest agencies to work with. On the temporary visa side, there are more than 40 different temporary visa categories, and basically they're all based about what the activity is that you're going to do. So certain visas are authorize you to do just certain types of work. What we're going to talk about today is the H-1B specialty occupation visa, which is really the most widely used visa for professional employment. We'll talk a little bit about the J1, the O1, but there are so many visas available, but usually for people coming out of a PhD program, there's just going to be a handful of options for you, but that's what we're going to talk about. So most of you, the majority of you here are here on F1, and when you leave Michigan State, you may look to get a job and to do that, you might need an H-1B visa. An H-1B visa is for specialty occupation workers, and those are defined as people who are working in a job that normally requires at least a bachelor's degree as a minimum educational requirement. So most of the jobs that you're going to be taking are going to be specialty occupations because you're going to be in PhD level jobs. But just to give you an example, the specialty occupation is defined by the minimum requirements of the position, not your qualification. So the example I like to give is registered nurses. So registered nurses, a lot of registered nurses now have bachelor's degrees, but that's still not the minimum. The minimum requirement for that occupation is still only 2-year associate's degree. And so because the requirement for the occupation is less than a bachelor's degree, the nursing occupation does not qualify for H-1B, even though you may have a bachelor's degree. And it's the same with any other occupation. You can have H-1B status for up to 6 years. Typically, you can get it in 3-year increments, 2 increments of 3 years each. And you can, in some cases, get an extension beyond the 6-year period, but only if you are pursuing a green card and you have reached certain milestones in that green card process. Right now, H4 spouses, H4 is the dependent category for H-1B visa holders. H4 spouses are not eligible for work authorization. We're going to talk a little bit about this in the executive action update, but there is a proposal to change that and maybe allow some H4 spouses to work. But right now, they are not eligible for work authorization. Another sticky issue with the H-1B visa is that there is a quota as to how many visas are available in a given year. The quota is around 65,000, give or take. The Immigration Service runs on a fiscal year that goes from October 1st to September 30th. And so this coming October, we'll be starting fiscal year 2016. So in that fiscal year, the USCIS can only issue 65,000 of these H-1B visas. The problem is, the last 3 years now, they've received more than 65,000 applications in the first week of filing. So they're gone in 5 days. I think last year they had up close to 150,000. So almost 1 in 2 or 1 in 3 people are only able to get the H-1B visas. There's a lot of proposals in Congress right now to change that because it just is not a very good system where we're basically relying on a random selection process to select who gets our H-1B visas every year. But until Congress takes action, which they're not very good at doing, we are stuck with this system. So right now, we're leading up to April 1st, which is for immigration lawyers is the busiest time of year because we're trying to file everybody's H-1B application for this H-1B cap. Now, there are certain employers who are exempt from the cap. And so if an employer is exempt from the H-1B cap, that means that they can file H-1Bs anytime during the year. They don't have to worry about whether there's numbers available or not. Cap-exempt employers are going to be institutions of higher education. Michigan State is a cap-exempt employer, so if you work for Michigan State, that you would not have to worry about the cap. Other nonprofit organizations affiliated with institutions of higher education. This one's a little bit tricky, but for example, we have a client who is a teaching hospital in Detroit. They are nonprofit, and they have an affiliation agreement with Wayne State on a lot of different levels, and because of that, they are able to also be considered a cap employer. But the Immigration Service looks very closely at what level of affiliation you have. It has to be a very tight and integrated affiliation with that institution of higher education. Nonprofit research organizations and government research organizations are also cap exempt. When we're filing for the cap and counting those 65,000, there's also a special exemption for individuals who have U.S. master's or PhD degrees. Basically, the way it works is that the first 20,000 applications received from individuals with master's or PhD degrees, they're not counted towards that 65,000. Now, in the past 3 years as well, that 20,000 cap has also been met. So if you as a PhD student are applying for an H-1B, you're going to get a first crack at it by trying to get it through the 20,000 exemption. If you don't get it through that, they then put you in the pot with everybody else, and you get one more chance at trying to get one of the 65,000. So you do have an advantage over someone who just a bachelor's degree educated individual who really only has one shot at it. You essentially have 2 shots, and that increases your chances a little bit. Another issue that comes up with the H-1B cap is something called the cap gap. A lot of times, depending on when your OPT ends, if you applied in after you graduated in like May or June, your OPT probably expires in June. And now the way the fiscal year works is if you apply for an H-1B in April and it's approved, the H-1B is not effective until October 1st. So your status doesn't officially change until October 1st. You can't start working until October 1st. But the problem is your OPT might be expiring in June. So what do you do about that gap of employment? Well, a few years ago, they passed some regulations that allow basically that if a student was on F1 OPT and it was valid at least through April 1st, and then on April 1st they can show that they have a receipt notice for an H-1B cap application that was accepted, then they can be eligible to have a special extension of that OPT work authorization through October 1st to get them to the point where their H-1B kicks in. You would coordinate that with Hirsch and his colleagues at the OISS, because they're the ones who will log you into their SEVA system and make the edits to your I-20 to make sure you have that authorization. There's a kind of an interesting issue, because this question has come up from a lot of people, but you can't, there's something called, well, on H-1B you can always do what's called concurrent employment. So if you wanted to work part-time for 2 employers, that's allowed. You can work 20 hours for one employer and 20 hours for another. That's fine. That's called concurrent employment. Now I don't even want to call it a loophole, but what the law does allow is that if you are working for a cap-exempt employer, let's say part-time, you're not subject to the cap, so you don't have to worry about these cap issues. But if you wanted to then also get concurrent employment with a cap-subject employer, you're actually still allowed to do that, even though the cap applies normally to that employer. So if you have a kind of a foundational position that's with a cap-exempt employer, that does allow you to do some part-time work with a cap-subject employer. Now, if you stop working at the cap-exempt employer, then you don't have that ability anymore. But Massachusetts is a state who's really looked at this and is trying to use this as an opportunity to retain people who, foreign students who want to start businesses and be entrepreneurs. And they've suggested this program where they will have a university, they'll screen people for entrepreneurial talent, and then they will offer them a job with their institution for maybe up to 10 hours a week, but then, which locks in the cap-exempt status, and then the person can go out and work for a startup the rest of the time, and that is not counted towards the cap. So it's kind of an interesting strategy, and so if you are a person who wants to start a business or be entrepreneurial, there may still be ways to do it. I was saying we should talk to Michigan State about doing something like that. That would be a great program. The one thing to keep in mind with H-1B status is it is an employer-sponsored status. Just like you can't get an F1 without your university's cooperation, you can't get an H-1B without an employer sponsor. So you can't just go out and say, I'm going to file for one by myself. So an employer has to offer you a job and be willing to file the H-1B application on your behalf. The law also requires that they have to pay for most of those application costs related to the H-1B. So you can't go to an employer and say, I'd like you to hire me an H-1B, but I'll pay for everything, because that's not permitted. Processing times are different based on whether you just file a standard application or use what's called premium processing. The standard applications right now are taking about 3 months, and then the premium processing is available if you pay an extra government filing fee of about $1,200, but then you can get them to issue a decision within 2 weeks. Now, because you're changing status from F1 to H-1B, immigration law says that when you're changing status, you can't start work until the new H-1B application is approved. So depending on the timeline for when you want to start work, that's going to dictate whether you would like to do normal processing or maybe this premium processing. So now the J1, we had a couple J1s. The J1 H-1B transition has some different issues as well. You certainly have all the cap issues to contend with. That still applies to you as a J1. But you may have another issue called 212E, the 212E home residency requirement that you may have to worry about as well. Basically, some J1 visa holders are subject to this home residency requirement, which says that after the end of your J1 training, before you can essentially move into another status or move into permanent resident status, you have to go back to your home country for at least 2 years, and then you can come back, or you have to get a waiver of that requirement. And the basis for that is the J1 is it's called an exchange visa program, so it's meant to have people come here, learn some knowledge, and then take it back to their countries. And so if you want to kind of circumvent that, they have to get a special waiver. Now there are ways that you can, well, so the people who are going to be subject to that 2-year home residency requirement will be people who receive U.S. or government funding for their education or training. So if you're a Fulbright scholar, you're automatically subject to that. Or if your field of studies is on the Department of State's skills list. The Department of State maintains a list of skills that they believe are in short supply in every country in the world. And if you're working in or you're studying in a field that's on the skills list, their preference is for you to go back to your country, apply that knowledge, instead of just staying here to kind of prevent a brain drain from your own country. So if you have government funding or you're on the skills list, you're going to be subject to that home residency requirement. I always tell people, when you get a visa, sometimes there'll be an annotation that says subject to 212E or not subject to 212E. They're not always right when they put it on there, so it's always a good idea to talk to an attorney and make sure that you either are in fact subject or not, because they often get it wrong. But if you are subject to the 212E home residency requirement, there are some ways that you can, if you don't want to go home for 2 years before coming back to the United States, there are some ways to pursue waivers of that requirement. One is through what's called a no objection letter, so you can apply to your home country's consulate in the United States, and they'll have a process where you can basically ask for their permission to have a waiver of this requirement, basically saying, will you let me stay here in the United States without complying with this requirement? Usually that process can take a few months. Some countries are more strict than others as far as issuing those letters. There's also what's called a hardship waiver. So if the hardship has to be a hardship to a U.S. citizen relative, it's not a hardship to you. So if you can prove that having to go back to your country for 2 years would create a hardship for a U.S. citizen relative, a spouse or a child, then you may be able to get a waiver of that requirement. It's got to be a pretty significant hardship, though. It's not just that, oh, we would have to pick up and move. I mean, it would have to be that, a lot of times, a great example is if, let's say you have a child who has a severe medical condition, and back in your home country, they would not have the ability to properly provide medical care for that condition. That would be a good reason. Sometimes if you have a spouse who would not be able to be employed or would create a very significant career issue for them, that may be a hardship, qualifying hardship as well. Persecution, on the other hand, that does have to do with you yourself. And so if you're just saying that if I had to go back to my home country now, that there's something going on with the country conditions and something going on with my background, whether it's my religion or any other factor, that I might be subject to physical harm if I had to go back, that would be another basis for a waiver. The last basis is what's called an interested government agency waiver. Certain government agencies can act as a sponsor for individuals for waivers. A good example is the Health and Human Services. For certain people who are working in the sciences, they may sponsor a waiver. Now, I just want to mention really quickly O1, because most of you are going to move probably into H-1B status, but O1 is a possibility as well. The O1 visa is for extraordinary ability. I think you're probably all pretty extraordinary. But this is the Immigration Services criteria for whether someone's extraordinary. A lot of people who are coming out of PhD programs, especially very high-level specific programs, they may be able to show enough of these elements to move into an O1. So if the H-1B cap strategy doesn't work for you, maybe an O1 is a backup option. For the J1s, just keep in mind, even if you do move to you can actually move to O1. That's the one category you can move into. But it doesn't alleviate that home residency requirement. So it might allow you to move into an employer and start working in O1, but at some point you'll still have to take care of that home residency requirement. So H-1Bs, J-1s, O-1s, those are all temporary work visas that have some limit on how long you can stay in those statuses. If you want to stay in the United States longer than that, then you may want to apply for what's called U.S. permanent resident status, or the slang term would be green card status. There are really 6 main green card categories. Some require a process called labor certification. What labor certification is, or it's called the PERM labor certification process, that's a process where the employer who's sponsoring you has to show that there's a shortage of U.S. workers in their region that no one is willing, available, or qualified to fill the position. So it can be a tedious process. It requires them to conduct a good faith recruitment in the labor market, and it can be a lengthy and complicated process. But not all categories require labor certification. One thing I didn't mention is H-1B. There's kind of a misconception that people think that for H-1B visas you also have to show a shortage of U.S. workers, and that's not true. For the H-1B, you just have to show that you're working in a specialty occupation and that you have the requisite degree in education to do that. There's no requirement of a showing of shortage. There is, however, in some categories of the green card. So this employment-based preference, first category, or EB1, will include what's called an extraordinary ability green card. Criteria are very similar to the O1. There's a category for outstanding researchers, multinational managers. The EB1 categories do not require labor certification. It's a major benefit. EB2 would cover people who are advanced degree professionals. So usually you're either in a job that requires a master's degree or at least a bachelor's degree and 5 years of experience. This national interest waiver category also falls under EB2. We'll go over that in a second. And then EB3 category would be for someone who is a bachelor's in a job that requires a bachelor's and something less than 5 years of experience. EB4 kind of for religious workers, and then EB5 is the investment-based visa for people who are going to invest in the United States. Similar to the H-1B, there are also quotas for the various green card categories as well. But the quotas are, there's a number of how many visas can be issued in each category, and then within that there's also a limit as to how many visas can be issued to a particular country in that category. Right now, countries that send a high number of immigrants to the United States those categories are backlogged because there are more people applying for the visas than there are visas available. Individuals born, and it goes by your country of birth, not your country of citizenship, but individuals born in India or China right now are contending with some pretty significant backlogs in both the EB2 and the EB3 category. For EB2, for most other countries, there's no backlogs, and there's no backlog for anybody in EB1. But you know, the backlog is pretty significant. I think right now, for example, in EB3, India is back as far as 2002, 2003, meaning that someone who started the process that long ago is still waiting to finalize the process and get the green card. Now they're able to stay here because of those special extension provisions we talked about that allow you to keep extending an H-1B while you're pursuing a green card, and that's how they're able to stay here. But it's frustrating that they have to wait that long. So the EB1, again, for a lot of PhD students, this could be a viable category for you. As you'll see, the criteria are very similar to the O1, it's a little bit more extensive. Essentially, you have to show that you meet at least 3 of these 10 criteria. The interesting thing about EB1 extraordinary ability is this you can self-petition for this. So you could either have an employer sponsor final application for you, or you could file an application on your own, just proving individually that you meet all of these, or at least 3 of these criteria. Now, there's a second category under EB1 called outstanding researcher. Now, first of all, this one has to be employer sponsored, so it can't be self-sponsored. And you have to be working you have to have 3 years of research experience, and you have to be working in a research-oriented employer in a permanent research position. So if you're in kind of like a short-term grant-funded position, that's probably not going to qualify. If you're at a company that really doesn't have an established research department, that's probably not going to work either. But if you are with a qualifying employer and you have a qualifying experience and you have a long-term permanent position, then you may be able to get a green card under this outstanding researcher category, which has less strenuous requirements. You only have to prove 2 of these 6 criteria, and even the strictness of the adjudications tends to be a lot more lenient in the outstanding researcher category as it is compared to the EB1 extraordinary ability. So it can be a really good option for some people if you're in the right situation. Also, now this is under the EB2 category, is something called a national interest waiver. immigration terminology can get confusing sometimes, but here, in the J1 context, we were talking about waiver in the sense of a waiver of that 212E home residency requirement. The national interest waiver, the waiver means a waiver of the need to do a labor certification. Because normally in the EB2 category, the employer would have to do that labor market test and show a shortage. But for some people who can show that they meet this national interest waiver criteria, the need to obtain a labor certification is waived. So waiver is used in two different ways between the J1 context and this context. But here, essentially, if you can show that you're doing some work that is inherently benefiting the United States in some very special way, you may be able to apply for a green card under this category and skip that labor certification process, so save you some time and save you some money in the process. EB5 is a real hot topic right now. It's always been around, but it seems to be being used much more frequently lately. And this is an investment-based green card. So any foreign investor who wants to invest money in the United States to start a business, if they invest up to $1 million, then they can get a green card under this EB5 category. If they're investing in a business or an investment opportunity in a targeted employment area where unemployment rate is 150% of the national average, then they can actually get by with only investing $500,000. Essentially, the way it works is they obviously very closely scrutinize your investments. You have to have a solid business plan. Sometimes there are opportunities to invest in groups that have already kind of set up a qualifying investment. Sometimes that can make it easier, or you can just do your own individual investment. But they will look very closely at your business plan, whether it's a legitimate business, where did the money come from that you're investing, the source of funds is a very important issue. And then you have to show that within 2 years that you'll be able to create 10 new jobs for U.S. citizens or U.S. permanent residents. So if your initial application for an EB5 is approved, you'll be granted a kind of conditional permanent resident status for 2 years, and then after 2 years, to have that condition removed and to be a regular permanent resident, you have to show that your business has grown and you've created these 10 jobs. And if you have, then you will become a regular permanent resident. Now, there's 2 ways to essentially get green cards. One is through employment or kind of work or investment, and the other is through family relationships. So on the family-based side of immigration, there are basically these 6 categories of relatives who can sponsor another relative for U.S. Permanent resident or green card status. So immediate relatives, the nice thing about that category is there's no quota for how many visas are available for immediate relatives. So if I'm a U.S. citizen, I can sponsor my spouse, I can sponsor my child as long as they're under the age of 21, because once they're over 21, they're not considered a child anymore. And I can sponsor my parent. And so there's no backlogs in this category. You can apply straight away, and typically in as soon as maybe 6 months, you can have a green card for that relative of yours. The one key thing to point out is we get a lot of questions about, well, I immigrated here, I'm studying at Michigan State, but we had our 2 kids here. Our kids are now citizens, and the question is, well, can they sponsor us? Can they help us in any way? They cannot sponsor you as their U.S. citizen, they cannot sponsor you as the parent for a green card until they reach the age of 21. So up until that time, unfortunately, they're not an immigration benefit to you, other than in that J1 hardship waiver context. If you have a U.S. citizen child, that may be a basis for a hardship claim. But for sponsoring you for a green card, they're not going to be able to do that until they're over the age of 21. And then these other preference categories do have quotas, and the quotas actually are quite lengthy, going from a couple years wait to sometimes more than 10 years wait. So the F1 and the F2 would be unmarried sons and daughters of U.S. citizens, and then F2A is spouses and children of permanent residents. So a permanent resident can also sponsor their spouse for a green card. But one thing to point out here is, let's say if you're applying for a green card and you're also thinking about getting married, if you can help it, and I know you don't always plan love around immigration, but it is Valentine's Day. But if you can, the best thing, if you can help it, it's much better to get married before you get a green card. Because if you get married before you get a green card, then your spouse is your dependent, and they actually can get a green card with you through the same process. If you become a green card holder first and then you get married, now you have to sponsor your wife or husband under this category, and there's a several-year waiting period to do that. So it's much better to get married before you get a green card, so you can both become green card holders together, because if you wait, then it can take much longer. And then this is married sons and daughters, married sons and daughters of U.S. citizens, and then the last category is brothers and sisters of adult U.S. citizens. And like I said, that's probably like a 10-year wait. I think for one of these categories, for the Philippines, the priority date is back in the 80s. It's crazy. Now, as I mentioned in November, President Obama announced his executive action. I guess the one thing to highlight here is the fact that he threw out a lot of proposals. A lot of those proposals are very good, but none of them have gone anywhere yet. I mean, the President and Congress are still fighting over immigration, and it's very unclear at this point whether these things will become effective, and if they will, when they will become effective. But there are some things that were mentioned in there that are very positive. Like I said, about half of the proposals he made have to do with people who are here without legal status. So there are some ways to something called deferred action to help people in those situations. But for people who are here in a legal status, there are some nice employment-based proposals that were put forth. It's just going to be, we just don't know yet when they're going to become effective and what the details are, because it was the details given were very broad and general in the announcement. But one of the proposals has to do with allowing some H-4 spouses to get work authorization, which would be great, because for the longest time they haven't been able to do that. And a lot of times, the H-4 spouse is, just as talented as you are, and again, would like to get out and contribute to the economy, but the ability not to work has been holding them back. What the proposal would be is not that every H-4 spouse gets work authorization, but only H-4 spouses of H-1B principals who have started that green card process. And if they've started that green card process and reached certain milestones, they're going to allow those H-4 spouses to also apply for work authorization. Again, we don't have all of the details. There was, the last I heard, that they had said that maybe this might be coming out towards the end of February, but we'll still see. It was, right now they did what's called the proposed regulations. They got comments, and now they're assessing those comments. And then the next step would be to issue a final regulation. And we are hoping to see that maybe within the next month or so, and then we'll have a lot better idea of who it will help. There was also a proposal to expand the OPT extension provisions, basically in two different ways. So one, as Hirsch mentioned, for certain individuals, you can get this beyond your normal 12-month OPT work authorization. You can get up to an additional 17 months, but only if you have a STEM degree. One of the proposals is that they would expand the number of degrees that would qualify for this, so maybe some degrees outside of STEM might be able to qualify. And then they're also talking about even expanding that 17 months further. So there may be the ability to get even longer periods of OPT work authorization in certain situations. They've also talked about expanding opportunities for inventors, researchers, people who want to start up companies and be entrepreneurs, to help foster that. This is probably the one that, to me, is the most interesting, but it's also the proposal that was the most vague. We really didn't have a lot of details of what they are planning here, but I like the thought. It's a good thought, and if they actually did something in that regard, I think that would be wonderful. They also are talking about making some more flexible options for people who want to change jobs while their green card application is pending. That process is called porting from one employer to another. The way that the green card rules work, sometimes if you have started a green card process but haven't finished and you're stuck somewhere in the middle, it can be challenging to move a job, because at certain points of the process, if you move jobs, you may or may not be able to transfer that H-1B or the green card process over with you, and therefore you might have to start the whole process over again. And so what they're talking about, and again, that becomes an issue when, especially if you're a person born in India, a person born in China, where you have started the green card process, but it may be many years before you get it. You don't want to be locked into one employer. You'd like to have the ability to move, and they're talking about making that a little bit easier, which would also be great. And then lastly, they've talked about streamlining the immigrant visa process, how they count those numbers for the quota. There's some talk about maybe only counting principal applicants, not the family members, so that frees up some numbers for different people from different countries. Maybe looking at other categories where we have unused visa numbers and putting them into other quota categories. That might help with some of the visa backlogs for individuals from India and China. And then also, just making the perm labor certification process more user-friendly. It's a really backwards process, very cumbersome, and if they could make it fit the real world a little bit better, that would be a welcome change. So that, I talked pretty fast, so that's why I wanted to make sure we covered some of these topics, because in talking to the folks at OISS, they said these were a lot of the issues that were very relevant to a lot of the PhD students. So hopefully I didn't talk too fast, but I was able to hit on some of the important points. And if you ever have any questions on these issues, obviously just feel free to contact us. We're very open to talking to people. We don't charge for phone calls, so just give us a call. Give us a call. Send us an email. We're more than happy to talk to you and understand your questions and your issues, because everybody's situation is very different. And it can be helpful to kind of talk through and see what your options are. And the biggest piece of advice I would give you is just plan ahead. The immigration process, it's a long journey, it's a long road, and it forces you to think far ahead. But the more advanced planning you do from an immigration perspective, the better off you're going to be. The worst situation you want to be in is where you've left yourself very little time to try to execute an immigration strategy, and then you're kind of rushing to try to get things done, and maybe you haven't even left yourself enough time to implement the right strategy. So plan as far in advance as you can. Start thinking about what your career path is, and go talk to an immigration attorney, and just have somebody who can lay out the options for you looking in the future. And I think you'll be better off. So thanks again for letting me talk to you, and hope everybody has a good Valentine's Day.
For more information about PhD Career Services, please visit www.careersuccess.msu.edu/PhD careers. Thanks for watching.